Many of you may or may not be surprised to hear that in many of the cases I deal with, parties subject to the claim or the offence send nasty or threatening messages to each other, intending to intimidate or harass the other party, which may not necessarily name the individual, but they might well be designed to threaten, intimidate, or even taken by itself amount to harassment or stalking of the other person. And this has become particularly prevalent in recent years on social media. So today I'm going to talk a little bit about cases that are prosecuted involving communications sent on social media or direct messages to other parties. But first of all, if you're new to me, I'm a barrister who helps you understand law, so make sure you hit the subscribe button and the bell icon so you don't miss out on anything. If you want your questions answered, you can become a channel member by joining the channel at the link below, or joining me over at Black Belt Secrets, which is my sister channel, also linked below. So first of all, it's important to look at how various offences are categorised. For example, there is what is called the substantive offence category, which prosecutors will look at in the first instance when considering an offence. These will typically include direct threats of one kind or another. That might be a threat to kill, a threat to commit criminal damage, typical harassment or stalking, which obviously are contrary to the Protection from Harassment Act of 1997, or an offence under a more recent category, which is controlling or coercive behaviour, contrary to Section 76 of the Serious Crime Act 2015. Various messages might also amount to blackmail, which is of course contrary to the Theft Act of 1968, and there are various other offences that come under this substantive section when prosecutors look for prosecuting such offences. And as is often the case, there is an overarching piece of legislation called the Malicious Communications Act of 1988, under which Section 1 creates an either-way offence, where the defendant might face up to 2 years imprisonment on indictment or an unlimited fine. There's an alternative offence created under Section 127 of the more recent Communications Act 2003. This is an either-way offence with a statutory provision for a time limit. The reason for the time limit in this case is that ordinarily there is a 6-month limitation period to lay the information or bring the prosecution before a magistrate. But in this case there is a 3-year limitation period beginning on the day that the offence was committed, and then there is a 6-month limitation beginning on the day that evidence came to the knowledge of the prosecutor which he or she considers sufficient to justify a prosecution. Now, many people will quite rightly raise the fact that Article 10 of the European Convention on Human Rights provides for the protection of freedom of expression. And this right, of course, includes the freedom to hold opinions, receive and impart information, ideas, without the interference of any public authority. In other words, to express their thoughts and views and ideas. However, as usual, different pieces of legislation interact with one another. Article 17 provides nothing in this convention may be interpreted as implying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein or at their limitation to a greater extent than is provided for in the Convention. In other words, there is a very careful balancing exercise between Article 10 and Article 17. For example, Article 17 provides that whilst you have the freedom of expression provided under Article 10, it doesn't give you the right to go about destroying anyone else's private and family life, by way of example. So looking at the Malicious Communications Act 1988 for a moment, Section 1 provides a fairly broad description of what might amount to an offence under this Act. Section 1 provides the offence of sending letters with intent to cause distress or anxiety. Any person who sends to another person a letter, electronic communication, or article of any description which conveys a message which is indecent or grossly offensive, a threat, or information which is false and known or believed to be false by the sender, or any article or electronic communication which is in whole or part of an indecent or grossly offensive nature, is guilty of offence if his purpose or one of the purposes is to cause distress or anxiety to the recipient. And for brief comparison, Section 127 of the Communications Act 2003 contains a broadly similar provision, which is the use of any public electronic communications network. Think all of the major social media networks and platforms. Again, a person is guilty of an offence if he sends by any means a communication network, a message or other matter that is grossly offensive or of an indecent, obscene or menacing character. So very often I've been asked the question as to whether anyone can do anything about these kind of messages which are intended to cause alarm and distress, intended to cause some kind of threat, or are simply grossly offensive in nature. And as you can see, there are both summary only and either way offences created by these pieces of legislation. There will also be what we call ancillary orders that are possible, which include criminal behaviour orders, which is in effect an order to comply with the requirements of that order, and restraining orders, which are often imposed in harassment cases to restrain a defendant from behaviour. Now, most social media platforms have taken to having reporting functions so that you can report such messages, report such people for doing this, report such people for sending such messages, blocking people, unfollowing people, and so on. But if you received a particularly horrific message, you can take screenshots of that message and you can submit them to the police and encourage them to prosecute. So as always, in most cases like this, evidence is everything. Document every single message, screenshot every single message. As horrible as it might be to keep them, if you want to get them prosecuted and you want to take this further, you need to keep a full diary of every single time something happened, the date, the time, who from, how it made you feel, all of which will go into victim impact statements if a prosecution moves forward. So with that in mind, I hope this gives you some understanding that these sort of things can and do get prosecuted in court. It is not simply a matter of sending it from a distance with no consequences. But having said all that, my number one tip with dealing with anything like this is, if you absolutely can, just ignore it, block the person, and have nothing to do with that person again. If you're in the situation where you have to deal with that person and there is no getting around it, you have to maintain communication in some degree or another, for whatever the reason is, then if you receive messages that are like this, then as I said, keep all of the evidence, document it well, and then you can present it. So please give this video a thumbs up if you find the information useful, and remember, stay humble and subscribe.